Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hi everyone, and welcome back to part 2 of our Cyberzone episode on demystifying ransomware and mandatory ransom payment reporting. This was recorded on the 2nd of July 2025. James, let's start with the million-dollar question. To pay or not to pay?
Yeah, so I suppose as an absolute last resort option where there's no alternative to recover business critical data that they can't recover through some other means or they can't live without. And I encourage any victim of these attacks to really challenge the notion of whether they can live without certain data sets. I've heard it from some clients that they were considering a ransom payment because they needed access to certain data sets in case the regulator was to ask for that data at some later stage. I would like to think that if a proper communication strategy was in place with that regulator, that they could perhaps be excused from providing such a data set, particularly if gaining access to that data set would require a payment of a ransom to a cyber criminal. But yeah, I suppose that's probably the scenario where I see a ransom payment being necessary, where it's a matter of life and death, or at least for the organization to continue their operations, where there's just no alternative. Yeah, we can talk about where this money flows to and how it's used. I know the sort of consideration, the ethical considerations are always there, but it's important to remember that these cyber criminals it's unlikely that they are just taking the money to go and spend it on a vacation or perhaps buy a new luxury vehicle with it. The reality is that they're reinvesting these ransom payments into their operations to allow them to undertake more and more significant attacks on potentially critical infrastructure like hospitals and the like. Yeah, that's probably where I see the need for a ransom payment, is where there's no viable backup recovery option for that company. And that might mean laying off staff or closing their doors altogether if they're not to pay for the decryption key.
Yeah, I tend to agree with you there that it's those scenarios where it's literally the difference between the company continuing its business operations or a key component of it, and the decision is, do we pay or do we have to let all these people go and they're out of a job? That can become a really serious consideration, and you can sympathize with the individual having to make that decision. And that's when it becomes very real world, where we're talking about potentially having to let people go out of their jobs versus something that might be a payment that the company can afford. They might have insurance for it. Touching on one thing that you mentioned there about regulators, we've certainly been involved in matters where data's been destroyed and the clients decided it's not paying a ransom, and we've helped the company deal with the regulator to explain that we're unable to provide certain information because it's been encrypted as part of a cyber incident, and we've not had that result in any issues. We've been able to work our way around that on matters that we've been involved in. But yeah, the regulator was understanding of the situation. So just make that point. Now, I know you've got a few things to say on this question. What are the reasons why you wouldn't pay? And let's assume that everyone listening all agrees no one wants to enrich a criminal. We understand that these organizations can use that money to reinvest in further attacks. Maybe they're also spending it on some European vacations too. But what are the key reasons not to pay?
Yeah, so I suppose I caveat my answer to this question always with the fact that I think I am a little bit tainted by my experience on lots of these matters. I've seen firsthand the sort of negative outcomes that can come from trusting a cyber criminal and paying a ransom with the belief that they're going to honor their word. At the end of the day, I believe that doing the kind of work I do ethically matters. This industry of ransomware is rife with people that are trying to make a buck and are happy to cross all sorts of ethical boundaries in doing that. We're often advising companies in the middle of their worst crisis that they've ever experienced. And so the choices that are made in those moments can have far-reaching consequences for their customers, for their employees, or perhaps even for society at large, the broader Australian economy. This is a Team Australia term that's been coined, but I try and bring a sort of a principled approach to each case. It means trying to be honest about the options and be transparent about the risks that are faced in paying a ransom, being thoughtful too of the long-term implications. So that requires us to start by making sure that we're treating victims with empathy. One of my favorite quotes, and something I think that stuck from when I first read it as a kid, is from Atticus Finch in To Kill a Mockingbird, which is, you never really understand a person until you climb into their skin and walk around in it. And that's how I try and approach every one of these ransomware matters that I work on. Even though I've helped hundreds of victims, for the victim I'm talking to today, it's often their worst day of their professional life. And so seeing it from their perspective, really empathizing, goes a long way to helping them feel supported and making those clearer decisions. But to answer your question directly, I'm of the view that there's little benefit, if any at all, that comes from paying a cyber criminal for the suppression of stolen files. The starting point is that there's absolutely no way that a payment of a ransom guarantees the deletion of the data set. You can't audit the process that a threat actor goes through to delete the files. There's nothing to say that they haven't already taken steps to sell portions of the data or shared it with other cyber criminals. And so that's really the starting point. If you look at the arguments that are commonly used for trusting a cyber criminal, one of these goes along the lines of they have a brand to protect. Why would they ever tarnish that reputation of their brand? And perhaps that's true in real world crime, the sort of gangs that we're used to seeing in Australia. A lot of the time, I think gang members in the real world are in that gang for life. That's not true in cybercrime. We see in the realm of cybercrime, cyber criminals are free to switch groups if and when they please. And so there's nothing stopping an actor who's working for one group today from coming back and working for another group tomorrow. And many of these affiliates are actually doing that. They may work for many ransomware groups at the same time. And the suggestion that they have a brand to protect, I think it's pretty futile, because they can freely switch between groups when they please, and they're happy to tarnish one group's reputation only to Phoenix as another later on. And we've seen that time and time again. Black Cat is probably one of the more public examples of that. The Black Cat group for a long time had what was believed to be a fairly trustworthy reputation, if you can call it that, in cybercrime. Only takes one event to happen where they decide to Phoenix and perhaps reemerge as someone else later on. They can end up leading to that. Those are where you see some of the most negative outcomes. So yeah, that's where my view stems from largely. There's a lot of other points though that go into that consideration.
Yeah, this is one of so just for those listening in, James used the phrase data suppression. What he's referring to is the cyber criminal comes in, they lock up your files, so you can get the key. That's one of the things you can get. The other thing is they typically are stealing data. The sort of encryption and the stealing of data, that's called, at least in cyber, double extortion. And it's that second, the double, is that they steal the data and they threaten to publish it if you don't pay the ransom. And many people listening will be familiar with that, given some of the larger breaches. And it's exactly what played out with the data then being published on the dark web. And so what James is often dealing with, and what we're often dealing with, is a situation where, particularly post 2020, a lot of companies are getting better at backups. So if you encrypt everything, who cares? You go and reload a backup and you might miss a little bit of data that can be reconstructed. But if you've got good backup systems, there can be very minimal disruption to the actual content of the data. Obviously, you need to bring in professionals, make sure that you don't restore everything and then there's something buried in the backups that can then be re-exploited by the criminal. So you want to make sure that's clean and it can be backed up and restored in a safe way. But then if the data's been stolen and the criminal is threatening to publish it, what James is going into is how can you really trust the criminal to do what they say? And this is a really difficult topic for many companies. Some companies do find themselves in a position where they understand the risks. They understand that the criminal, you pay them once, they could try to re-extort you. They'll say that they'll send you evidence that they've deleted it, and often they do. But as James rightly says, you can't audit that. You don't know if they've made a copy of that before they delete it or appear to be deleting it. And in fact, there's evidence that one of the big groups who were saying that they were deleting everything. When they got raided by law enforcement, to no surprise, they'd actually retained a copy of all the stuff that they'd shown to be deleting. And so there's this challenge where, if you pay simply to stop data from being published, how can you ever know that it's actually going to be, that promise is going to be adhered to? And really, there's no recourse. You can't, this is not a commercial transaction where you can go to the other party and say, hey, you didn't honor your word. I'm going to bring legal proceedings against you to do what you're supposed to do. Once the payment's made, the payment is made. So there's some really good reasons not to pay. I have found, though, with all of that said, and we obviously always present all of these risks to clients, some clients do just feel so compelled to take the step to pay because of the sensitivity of the data, or because it's an option that they're prepared to entertain to stop the publication. And in fairness, the payments that we've seen clients make really have, at least in terms of publication on the dark web, which is where the data is typically published, and James is right to say it could be sold in back alleys that we don't know about. That's entirely possible, but certainly matters that we've been involved in where payments been made for data suppression that has had a good outcome, in that the data has not been published on the dark web. And James, I think it'd be fair to say that the majority of matters you're involved in where payment is made, the data is not then published as well. Would that be a fair comment to make?
That is certainly true, but I think it is also important to the general public that we educate people on what the actual ramifications of having data leaked on the dark web is. The true wheeling and dealing of data sets for exploitation happens on closed forums out of view. So just because a data set's been leaked publicly on a dark web leak site belonging to one of these ransomware groups is not indicative of that data set being more likely to be exploited. I think, and this is a personally held opinion, I don't think the visibility of where a data set gets leaked, be it publicly or perhaps on a more private forum, changes the risk of harm to individuals that are impacted in a data set. And when I talk to clients about this, when you pay a ransom, you're not only trying to solve your problem, you're fueling the next attack on someone else. We encourage clients to focus on what they can control in an incident like this. And as we've discussed, having strong backups, knowing how to restore quickly, and being ready to communicate transparently with customers and stakeholders is so important. I think certainly I always encourage taking an honest and responsible approach to disclosure. It can go such a long way. People in Australia are not stupid. I think people recognize that if a company that holds their data was to pay a ransom to a cyber criminal, that doesn't actually go a long way to alleviating the risk of harm to themselves. This is where I think Western countries have done really well to implement schemes like we have under the Privacy Act here, where it's still mandatory for companies to report these breaches to impacted individuals. I've never seen a company go under because they admitted to a breach. We've seen many in respect by doing the right thing. And I think that's where corporate Australia needs to see an opportunity, rather than perhaps something that they can brush under the rug by making a payment. It's companies that do the right thing by their customers, and that transparent approach that I applaud. And perhaps something, I know we've talked about the incidents in 2022, but another thing in hindsight about those incidents is I think it put Australia on this course which we can't really get off now. And it's the right course. It's the course that results in victims of these attacks paying where they absolutely need to for a decryption key, but where it's just a data theft incident, as you highlighted, most of those incidents around that time were, these victims chose not to pay when some of the most sensitive information was exposed. And I think that's helped a lot of smaller entities where perhaps the data set wasn't as sensitive, or it was much, much more limited in size and impact. It's helped them to make the same decision, which is, it's a bold decision for any organization to make, but I think one that we should applaud as society, rather than trying to perhaps kick victims while they're down.
Yeah, I think you touched on regulatory piece, and that's probably a good segue to move on to ransomware reporting, because that's one of the things. I think we've demystified ransomware a lot so far, and so it's been a really good and robust discussion. Just for completeness, with the privacy notification obligations, there is a scenario where if you take remedial action before serious harm eventuates, that's a means by which an organization may not be required to notify individuals or the regulator. The regulators provided some guidance on this very point to say the paying of a ransom, in the regulator's view, is not remedial action. So if you pay the ransom, with the thought being, if I do that, then I don't need to notify my customers. The regulator certainly has a different view to that. They're of the view that you cannot trust the criminal, consistent with James's point here. You can't trust the criminal, so therefore you're not able to be satisfied that remedial action's taken place, and you still have to notify people. I just thought it was worth mentioning that point because it's an important one that does come up in matters that we're involved in. And now that we're talking regulator, let's talk about mandatory ransomware reporting. I said at the top of the episode, we're the first country in the world to introduce it. It's been applauded by many people in different jurisdictions as a good step. Good to see this step being taken. What's your views on ransomware reporting? And do you think it's going to lead to a decrease in ransom payments now that companies think, if I'm going to have to tell the government anyway, maybe I don't want to do it?
Yeah, so I likewise think the introduction of this scheme is a really important step forward. For so long, as I've already elaborated on, there's been this massive gap between what's reported to the government and what's actually happening on the ground. CoveWare's seen that firsthand, especially I think as it relates to medium or smaller organizations. And this scheme gives us a clearer window effectively into the scale of the problem, which I think is essential if we're to try and find an effective countermeasure, effective way of solving the problem. With that said, the current scheme only applies to organizations with a turnover above 3 million. I think there was a real missed opportunity there. Smaller businesses are often the most vulnerable to ransomware, and so by excluding them from this, the reporting requirement or alleviating them from having to report means we're still missing a huge piece of the puzzle. And I don't want to sound too critical here because I'm very supportive of the legislation, but I can't really see why the report itself needs to impose a cost burden on small businesses. It's a simple few-minute web form that you submit to the ASD. Sure, you may want to take legal advice on that, but we make small businesses take legal advice on tax decisions they're taking or on other sort of legal issues that arise. I don't see why Australia's taken the step to carve out small businesses in the way it has. But anyway, the law's impact will depend, I think, entirely on how it's implemented. If agencies like the ASD are flooded with unstructured, low-quality data, then the scheme risks creating noise instead of the insight that it was setting out to try and provide. So if we can get to a point where the design of that process works well and there's structured data that's scalable, that we can actually use in a meaningful way, then that's going to be critical, I think, to the success of this. But importantly, I think organizations that going through this need to remember that reporting a ransom doesn't give you a free pass insofar as sanctions and the legality of payment are concerned. So if your organization's dealing with a sanctioned ransomware group, the legal risks are still there. You need to seek expert guidance from law firms such as Eden's, and also in considering the technical fingerprints or the indicators of compromise that are present on any case to assess whether you may be dealing with an actor that's either part of a sanctioned group or associated with a country that's comprehensively sanctioned. To touch on the point you made, Eden, about the perhaps underappreciated benefit of mandatory reporting, I agree. I think there's certainly a chance, I think a very good chance, that it will actually reduce the number of ransom payments. Just for any organization that's on the fence, it's an additional argument as to why perhaps they may not pay a ransom, knowing they have to report and then justify that payment to the government. It'll push many organizations, I think, to think twice. And it won't be all. It'll be a percentage of victims that would have otherwise paid. But I certainly think that benefits perhaps been a little bit underappreciated, especially when the payment's going to be about data suppression only rather than restoring their operations. I think that's where we'll see the most positive shift. So yeah, all up, I think the scheme is promising if it's implemented thoughtfully and backed with the right support from enforcement. But I think yeah, this is just another reason why I think Australia has a real chance to lead globally on this issue.
Just a few things to unpack there that I thought I'll quickly comment on. Yeah, just for those sort of not familiar with the legal question of can you pay a ransom, James has touched on what is the key issue, which is sanctions. Criminal groups or individuals who are sanctioned, who are on the sanctions list, it's a criminal offence to pay them, and it just simply cannot be done. So if you are dealing with a sanctioned entity, we strongly recommend against payment at all, and to even assist someone facilitate that can be an offence too. If you're lawyers, if you go without saying, if you're a company who's been hit with ransomware and you're considering paying, please seek legal advice. It doesn't have to be from me. I'm happy to help, but just please seek legal advice from a solicitor. Then in terms of the $3 million threshold, I know so that's the number that mirrors the Privacy Act, that the government is looking to potentially remove that rule, the small business operator exemption in the Act, so that the Act applies to everyone. With the Privacy Act, there is a fair amount of cost involved in compliance. It can be an onerous act for some. And so for historic reasons, it hasn't applied to small businesses. Again, the government's looking to remove that. For something like simply reporting a payment of a ransom, I agree with you, James. I don't see why it shouldn't apply to a business with a $2.9 million revenue, but it does to one with a $3.1 million revenue. It is simply going to a website. Maybe that's something that will evolve. If I had to guess, I'd say it would. I think the team who's drafted the legislation should be commended, and they've done a really good job to get it in. And most legislation, it does evolve over time, and that's what amendments are for. James, I know that was your point, that you made that before I did when we were preparing for this, so I'll give you the credit, but I suspect it will go away.
I don't want to sound cynical in criticising gaps in the legislation, because I think it's certainly breaking some new ground internationally, and I'm very supportive of what's been implemented. But yeah, there are, I think, some opportunities there for some amendments in the coming months, perhaps around also looking at other carve-outs that we've discussed, Eden, and I think we've chatted a little bit about these AML, CFT, reporting entities under the Privacy Act that perhaps may or may not be covered under the Cybersecurity Act, as well as opportunities that large international conglomerates might have to avoid reporting, and other things like what potentially happens if you have a smaller subsidiary that may fall under that threshold. So yeah, there's certainly some things for the lawyers. I know probably your listeners will think we're getting a little bit too much into the weeds of the legislation at this point, but this is probably not what keeps them all up at night. But it's the thing that people like you and me spend our time thinking about.
Yeah, it's something we haven't actually even talked about before. And it's only happened on a very recent matter that we're working on, a ransomware matter where one, and I won't name who the bank is, but it's an Australian bank. It's a very well-known bank. And there were sort of certain payments being made, not to pay a ransom, but just in relation to engaging vendors that could lead to a ransom payment. And for the first time, the client was sent a string of questions from the bank making inquiries as to what the payment was about. Now, for those who are familiar with some of the APRA regulations, and in particular CPS 230, we think that the bank is now taking steps in terms of potential ransom payments as well. And so companies could find themselves in a situation where the bank won't even allow the payment to go out without doing its own due diligence. So that's going to be, I don't know if you've seen that or anything. That was literally something that's fairly hot off the press in the last couple of weeks on a matter we're working on. But that was a new development that we hadn't seen before, which I found to be quite interesting, and will be another hurdle to overcome in relation to ransom payments.
Yeah, interesting take. We'll be watching closely. Yeah.
A huge thank you to you for taking the time to share your insights and knowledge and expertise with those who are listening. And also a big thanks to those listening in today. As always, get in touch with us if you have any questions. Please reach out. You can find our details on our website, which is hallandwilcox.com.au, or connect with us on LinkedIn. And if you enjoyed today's episode, then follow our podcast on your favorite podcast platform. Thank you very much, James.
Thanks, Eden.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.